Hi, in continuation with the lecture on introduction and scope of cyber laws, I'm going to explain the key features of this legislation under the channel Cyber Jurisprudence. As I have already mentioned this slide in the previous lecture that was on Information Technology 2000 and overview, and I had already explained that this legislation is considered as the very first legislation in India on the regulation of digital interactions and digital crimes electronic commerce. Significant updation was made in 2008 to address emerging cybercrime challenges and technological developments, and it was considered as it was a hurry legislation. Then it got further amended in 2015 with the case of Shreya Singhal vs. Union of India, where Section 66A was struck down. And in the current status, we upcoming with the rules so that to keep it along with the upcoming challenges. So if we see in this way, in 2000 it got enacted, in 2008 major amendments, in 2015 section 66A was struck down. I will not say it is an amendment or some changes were made in the legislation, but this section was declared unconstitutional. In 2017 there was amendment, but a major judgment came into existence where right to privacy, which was earlier not declared as a fundamental right, has been declared as a fundamental right. Now we have right to privacy as a fundamental right that came with the landmark judgment by Supreme Court in K.S. Puttaswamy vs. Union of India. In 2023, there was no as such amendment in IT Act, but a big support related to data has come into existence in the form of DPDP Act, that is Digital Personal Data Protection Act 2023. But yes, with this legislation, major impact is seen in BNS Act 2023 related to data and so many provisions which we will be discussing in the upcoming lectures. So again, a very glimpse overview that the legal foundation was laid down in 2000. It was a first comprehensive attempt to address electronic records and cybercrime issues. So in the original provisions, there were so many legislations and sections which were not added related to, for example, related to electronic contract and the latest emerging crimes. So in 2008, major changes were introduced and enforcement powers were given more clearly. So in the IT Act, there are so many important definitions. However, as a beginner, you need to understand the definition of computer that is given under Section 2, Subclause 1, Subclause I. Another important definition is given on data under Section 2, Subclause 1, Subclause O. Most important definition on the cyber security is given under Section 2, Subclause 1, Subclause NB. And other important legislation that is on digital signature is mentioned in Section 2, Subclause P, and intermediary Section 2, Subclause 1, Subclause W, which speaks about what is the intermediary, what is the liability of intermediary. So all these sections and definitions are very, very important to begin with understanding of this subject. Now, if we see the nature of IT Act, it is majorly discussing the cyber crimes. Very obviously, it is very important to understand the nature of cyber laws, and IT Act is both. It is civil as well as criminal. So when I'll explain and go deeper into the subject, I'll also explain the civil nature of this legislation. However, because as a beginning of this lecture, most of the major focus of understanding this subject is on crimes. So we need to understand little bit on the cyber crimes. As a student of law, you must have read about the legal foundation of criminal law, and we all are aware that there are two most important things in order to make a crime a complete crime, that is Actus Reus and mens rea. So Actus Reus means the guilty act and mens rea means guilty mind. So the physical component of cybercrime involves observable action like unauthorized access and unauthorized system spreading malware, like act of hacking, act of data theft, act of web defacement. So this is a actus reus, means if I am doing one particular act, it is a much ahead step than thinking. So the thinking and planning is reflecting in the act. And the second most important part which makes an act a crime and a guilty act is the guilty mind. So the mental component and mental element represents criminal intention when executing digital offenses. So how do we understand the mind of a person? It is very, very difficult to read the mind of the person. So it depends upon case to case how to understand that whether behind doing a particular act there was a guilty mind or not. Because guilty mind means deliberate fraud, intentional data theft, and purposeful system damage. So now here I would like to add something on the basis of my experience, that you can see in the third image there is a court. So in a court सीधा ही crime होने के बाद केस नहीं जा सकता. There is a long procedure. Only after following that procedure, a case appears to the court in front of a judge. So it means if there is an act, obviously after the act, there is investigation by the police. During the investigation, police gathers the evidences, and if it seems that there is proper well-framed crime, only then the charges are framed and then the case begins. So the most important thing is, can we say that in a cybercrime there are chances that there are no mens rea? So in order to understand this particular question, we need to see the nature of the crime. And most importantly, cyber crimes are based on skill. They are skill-based crime and white-collar crime. So what is skill-based crime and white-collar crime? It means that in order to do this crime, we need a skill. Any person who is illiterate and any person who is not aware about the technology, who is not having gadgets, cannot hack the system. So it is considered that जितने भी वाइट कॉलर क्राइम्स हैं एंड द साइबर क्राइम्स हैं, दे आर स्किल बेस्ड, एंड वहाँ पर मेंसरिया के प्रेजेंट होने के चांसेस बहुत ज़्यादा होते हैं. If there are exceptions, they will have to prove in the court. But generally, it is presumed that if a hacking is done and if the system of a nation has been hacked, if there is a business of cyber pornography, there is a obscenity, there is a publication of such images which are against the public policy of India, how can we say that there was no mens rea? These things are not done by chance and by mistake. If the image of a person is morphed, obviously the tools are used. Obviously there is a target, there is a planning. No one can do this without any planning. Therefore, in a cyber crime, actus reus and mens rea is presumed to be very, very high, because such crimes are committed with intention and with planning, with a proper target. So आज की डेट में देर आर सो मेनी पीपल जिनको पासवर्ड भी याद नहीं होते, अपने पासवर्ड रिकवर करने पड़ते हैं. कैन सच पीपल plan a proper hacking and targeting the server of another company? We will have to see into the facts and circumstances of a case. But as a very foundation, as a student, as a learner of cybercrime, you need to see the act and then the guilty mind. Only then we will go to the police, and then FIR will be lodged and investigation will be started and evidences will be gathered. And when all these steps are there, the court will see the evidences of digital actions, proof of criminal intent, and there are, if certain exceptions, then it will be taken into consideration. So when we start understanding the cybercrime, we need to understand that cybercrime के subject में computer is considered as a tool also and as a target also. Computer as a target means attacks directly aimed at computer systems and networks. Suppose I want to hack the account of another person. Obviously, I cannot hack a person. I'll hack the computer system of that person. So it is hacking and unauthorized access, denial of service attack, and malware distribution. Malware distribution means I'm targeting the computer of another person. Similarly, computer as a tool, obviously computer tool की तरह भी use होता है. If I want to use computer to conduct a crime, I need computer and I'll use it as a tool. I need a computer. And with my computer, I am targeting another person. So in this topic, there is a little bit overlapping also. In identity theft means I want to steal your identity. I use my computer as a tool to target you. And cyber stalking and harassment, obviously for doing all such type of crimes, I need computer as a tool. So the impact and threats are very, very serious. So multi-dimensional damages are there when we use computer as a tool and target for a cyber crime. There can be financial losses to individuals and businesses. There are privacy violations and data breaches, national security and infrastructure risk. And so many enforcement challenges are also involved. I have mentioned as in the previous lectures, jurisdiction limitations. We need international cooperation, and that so many times we do not get because of international conventions and treaties all around the world. Most importantly, for investigating computer and digital forensics, we need technical and legal experts. Many times, because of lack of expertise, lack of technical knowledge, so many investigations, they just end up into vacuum because they don't have proper expertise in that. So if we see about the popular cyber crimes, it means the criminal activities where computer, network, and digital devices are used. Hacking. Hacking means unauthorized access to computer systems to steal and alter data. Phishing. Phishing means fraudulent attempts to obtain sensitive information like passwords and bank details. And malware. Malware means malicious software designed to harm or exploit digital devices. And other emerging cybercrimes are data breaches, means unauthorized access or leakage of confidential data from secure system. Deepfake, very popular, AI-generated synthetic media used to manipulate digital content, often for deceptive purposes. And digital evidences, as mentioned, we will study it in more deeper, like it is very, very difficult to gather digital evidences. So in the category of cybercrime, the most prominent one which are affecting each and every person of any generation is online banking frauds, means unauthorized access to bank accounts through credential theft, malware, and social engineering. UPI fraud, fake payment links and UPI handles designed to steal money from unsuspecting users. And cryptocurrency scams, Ponzi schemes, and fraudulent investment opportunities using digital currencies. Here we need to know that in India, cryptocurrency is not a legal tender. It is not being regulated. So if we see what are the laws if a person is subjected to a financial fraud, under under IT Act 2000 as amended in 2008, Section 66C speaks about identity theft, and Section 66D speaks about cheating by personation. So while listening to this lecture, please keep ready the IT Act with you, because in detail you can read the section and you can see the punishment. It is 3 years and fine. Now the corresponding provision under BNS, earlier under IPC it was section 420, cheating. Now under BNS it is section 308 subclause 4, which speaks about such type of cheatings. Now the second most prominent cybercrime is cyber terrorism. As I have already explained, cyber terrorism means attacking on the government against the nationality and sovereignty of any nation. And this crime is considered very seriously because in India, in IT Act, this is the only legislation where life imprisonment is given. So critical infrastructure threats means attacks on government networks, military infrastructure, or critical information system with the intent to cause harm, disruption to national security. Then AI-driven attack, as we have seen in the war in Russia and Ukraine, AI was the lead in sensing and in targeting the areas. So recent example of AI-driven cyber attack on Indian defense system that attempted to compromise sensitive military information. National security impact. It has potential to disrupt essential services, compromise national security, and create public panic through targeting digital attacks. In an IT Act under Section 66F, it means if any act is in threatening the unity, integrity, sovereignty, and security of India, there will be life imprisonment. And in BNS earlier under IPC, there was Section 121, waging war against the nation. Now there is Section 147, that is BNS 2023, that deals with this particular terrorism. Most importantly, most emerging is artificial intelligence and deepfake cyber crimes, AI generated misinformation, deepfake pornography, and digital defamation. So, here, if such type of crimes occur, we will have to see that what is the impact. If in a deepfake there is a sexually explicit content, then Section 67A will come into picture. And if it is obscene content, then Section 67 will be considered. So in Bharatiya Nyaya Sanhita, Section 354C, it was in IPC related to voyeurism, but now in BNS, it is Section 75 and Section 77 on voyeurism, which are dealing with such type of crimes. Now, darknet, deep web are kind of like Tor browsers where IP address is not getting traced. So these are putting a lot of challenges in front of legal jurisprudence, because for investigation we need IP address, but if a criminal is working in Tor browser, darknet, and deep web, then it is even difficult to trace the footprints. And in darknet and deep web, all the illegal drug sales, sale and purchase of children, sale and purchase of arms and ammunitions, which are prohibited in India, all the illegal businesses are flourishing and it is difficult to detect them. These are anonymous marketplaces and full of illegal goods, illegal drugs, cryptocurrency payments. But the problem is that cyber criminals exploit the anonymity of the dark web to do such type of illegal businesses, because it is difficult to track, and most importantly the issues become very serious when cross-border jurisdictions are involved. So do we have laws? We have to see that what type of act is being done with the help of dark web and deep net. If it is drugs, then we have NDPS Act 1985. If it is any other crime, we will have to take that particular legislation into the help, that how to address these provisions, because on darknet and deep web as such we do not have any other specific section and provision. We'll see the effect of the crime using these platforms, then we can frame the charges. This crime is affecting our kids a lot. Cyberbullying and harassment. Cyberbullying and harassment means it is social media harassment, that persistent target through public posts, comments, and messages. Direct harassment is through messaging platforms like WhatsApp and any other private messages. Email harassment, sending threatening and abusive content to victims' email. And doxing means publishing private information to encourage harassment by others. So cyberbullying case is very popular among the school children, because they are in such a tender age that they do not even understand that this is cyberbullying. And many times kids and students and the children of tender age do not even discuss with the parents, because they do not want to listen to any type of criticism. As a result of cyberbullying, there is a low performance in academics, social withdrawal, and so many severe psychological distress. And I feel that this offense should be treated very, very seriously, because it is going to destroy the entire career of a children from a very tender age. However, sadly, we do not have specific provisions related to cyberbullying. We had Section 66A, which once addressed offensive messages, but it was struck down by the Supreme Court in Shreya Singhal case, being overly broad and unconstitutional. I'll explain this topic when in the coming slide I'll discuss Shreya Singhal case. Now, what is the provision of cyberbullying? Under Section 67B, if there is a content which is targeting children, and there is online harassment, we can involve this provision. And under BNS, under Section 78, we can cover. But sadly, the seriousness of this crime is not taken into consideration very seriously, and we do not have any effective provision on this. So thank you so much listening to me. In the next lecture, I'll move forward from this lecture. I hope you are understanding the content. Thank you so much.